Kuzampala, and a very warm good morning to the speakers, moderators, and the distinguished guests who are virtually attending and both in person. I have the honor to welcome everyone to the second day of National Conference on Public Contract. My name is Theong Hamo, and I will be your MC for today, leading you through the transactions of the program. For today, we will have 4 sessions, and the first session will be moderated by Associate Dean for Clinics, Demalham. If I may introduce her briefly, Demalham is the Assistant Professor and Associate Dean for Clinics at JSW School of Law. Before joining the law school, she worked as a Senior Legislative Officer at the National Assembly Secretariat. She received her Master's of Law with specialization in criminal justice and criminology at the University of New South Wales, Australia. Demmer teaches human dignity clinic and penal law and restorative justice. She also co-taught criminal procedure and evidence law and human dignity. In 2016, she also co-taught a short course on law and development at the University of Vienna. With this brief introduction, I would like to invite moderator Demalam to take over the session now. Thank you, La.
Thank you, Tawang. Distinguished participants, dean, colleagues, students, and friends who are joining us virtually. Sorry, let me take out the marks. Sorry. Distinguished participants, dean, colleagues, students, friends joining us virtually, Kusazangpo, and a very good morning. Before I start, I would like to join the nation in wishing His Majesty Aju Gyalpo a very happy birthday and offer my prayers for His Majesty's long life and good health. I would like to also thank the conference organizing team for giving me the opportunity to be a part of this conference today. It is my privilege and honor to be moderating this morning session of the second day conference today. We have a wonderful panel today that will discuss the challenges and issues associated with setting aside arbitral awards by the court, public procurement rules and regulations here in Bhutan, its challenges, and also the new development that is taking place around public procurement here in Bhutan. And finally, the panel will discuss the interaction between the competition law policies and the public procurement policies with focus on bid rigging and advocacy. And before we begin, just some housekeeping before we get started. Each panelist will get a 15-minute time to do their presentation. I would like to request the presenters to be very mindful of the time limit that we have so that we can have time for discussions later after the presentation. I would also like to request the presenters to share their presentation from their screen. We do have a backup here if in case there is a technical problem from your end. And also would like to request the presenters to please keep your video on while you are presenting. And to the audience, if you have any questions, please type in the chat box while the presenters are presenting or after they're done with their presentations. So we have a question and answer session after the presentations are done. To start us off, we will now turn our time to Trungpan Tenzin, who will talk about the setting aside of arbitral awards by the court and the challenges and issues associated with it. Trungpan Tenzin currently works as district judge of Chukwa District Court. Prior to that, he served as a judge at Pemagasal and as a registrar at Bench 4 of Thimphu District Court. He was also the personal secretary to Her Royal Highness Ajisonam Dechen Wongchuk at Bhutan National Legal Institute, where he carried out numerous research and provided training to the judicial personnel. Trungpan Tenzin was also an adjunct instructor at Royal Institute of Management, where he taught many PGDNL courses. He also worked as a legal officer with Renew, a civil society organization here in Bhutan. He has a Master's of Law in International and Comparative Law from George Washington School of Law, Washington, D.C., USA, a Bachelor's of Law LLB honors from Nalsar University, India, and a postgraduate diploma in National Law from the Royal Institute of Management. Over to you, Latasho Tenzin.
Lasla Gara Kuzambus Shugela. First of all, let me share the slides. This is to be more Karagi. Karagi is this to be more.
Tomela.
Lasla Kuzampo, and very good morning to everyone. And first of all, congratulations and thank you to the JSW and the organizing committee for organizing the first National Conference on Public Contracts and for the opportunity to be part of this. And to my distinguished co-panelists, it is such an honor to be part of this panel. And thank you for our session moderator, Assistant Professor Dimalam, for your kind introduction and moderating the session. An effective dispute settlement regime is indispensable for an effective public contract system in any jurisdiction. And ADR is now the most popular form of dispute settlement in many countries, especially disputes relating to commercial activities. And a robust, effective, and efficient recognition and enforcement of arbitral award regime is an integral part of successful ADR system, which has to be backed by a strong and independent institutions and effective laws. So when we talk about ADR system, arbitration as a method of dispute resolution is a relatively recent phenomenon in Bhutan. However, ADR, when we talk about ADR mediation, is also an important concept which predates, at least in Bhutan, the litigation system. So in the interest of time, I'm going to skip my first two slides probably, which gives you a very brief background of the ADR system in Bhutan and also the legislative framework. So I'll basically jump into the main theme of my presentation, that's basically talking about the role of courts in the arbitration. So let me begin with the brief introduction of general considerations in arbitral award when a dispute is referred to the ADRC, and the arbitration tribunal considers the dispute as per the ADR Act. So first is the governing law, and the governing law is basically the substantive laws of Bhutan as per section 127, and it has to be decided in accordance with the terms of the contract between the parties, and it is by way of simple majority decision under the section 131, and decision has to be based on reason, and once the decision is given by the arbitration tribunal, it is final and conclusive. So if one of the parties is not happy or aggrieved by the arbitration decision given by the arbitration tribunal, then they have 30 working days in case of domestic arbitration, and 90 plus 15 days for special circumstances, working days for international arbitration to file a petition before the High Court to set aside the arbitration award. So the scope of my presentation is basically limited to the cases that's decided by the High Court in last 2 years, in the year 2020 and 2021. And there's the grounds which are set specifically under ADR Act, and that's incapacity of the parties to enter into an agreement. And invalidity of the arbitration agreement is also one of the grounds for setting aside the arbitral award. And if the parties or if the arbitration tribunal did not give proper notice, then it also becomes one of the grounds for setting aside the award. And if the award given by the arbitration tribunal is beyond the terms of submission to the arbitration, and if there are any procedural irregularities in conduct, for example, if there is any procedural irregularities in appointing the arbitration tribunal, then that also becomes the grounds for setting aside the arbitration decision of the arbitration tribunal by the High Court. And further, if the court finds the first ground is if the parties alleges and if it proves, then the High Court can set aside the arbitration award of the arbitration tribunal. And the second is if the court finds that the arbitration tribunal lacks subject matter jurisdiction to issue or decide on the dispute. And the second is public policy doctrine. So once the High Court has reviewed the decision of the arbitration tribunal based on these grounds, then basically it can either confirm the award or set aside the award in whole or in part and itself determine the matter. So for this purpose, I basically reviewed around 14 cases, as I said, from the year 2020 and 2021. And the nature of the cases are basically disputes arising out of public contracts, and mostly between the procuring agency, the Ministry of Works and Human Settlement, and the private contractors. And a few cases concerns subcontract works, for example, if a contractor, if the principal contractor has subcontracted any part of the works, then some of the disputes relates to these disputes between the principal contractor and the subcontracts. And talking about the common grounds of disputes, it's mostly breach of contract, mostly failure to complete the works on time by the contractor. And in most of the cases, it also deals with termination of contract by the procuring agency for failure to complete the works on time, claim for liquidated damages, and reimbursement of cost of bitumen supplied by MOWHS or the procuring agencies. And how were these cases referred to the High Court? So when I reviewed these cases, it is by way of appeal to review the merit and the substance of the award. So it's basically appealed like any other cases from a trial court. So there was no appeal which was made specifically on any of the grounds specified under Section 150 to set aside the award. And the court, the party did not make any allegations, nor it proved any of the grounds provided under Section 150. And the court also did not insist on any specific reasons or proof why the arbitral award has to be set aside. So basically, it ended up appealing like any other appeal from a trial court, basically requesting the court to review the arbitration tribunal's decision on merits, not really on the grounds which is clearly specified under Section 150 of the ADR Act. So if you read these cases, then basically the court says that the review or the petition submitted by the parties are reviewed as per Section 110 of the CCPC as opposed to Section 150 of the Act. In fact, when the High Court receives this appeal from arbitration tribunal, I think this has to be reviewed not as per the general provisions of the civil and criminal procedure, but under the specific provision of Section 150 of the ADR Act. So looking at some of the grounds, some of the common reasons why these parties, though they voluntarily enter into an agreement, arbitration agreement, saying that in case of any disputes, this will be referred to the arbitration tribunal. But in most of the cases, they tend to appeal to the High Court. So the first common ground was merit of the award, basically saying that it lacks reasoning. And the second is erroneous interpretation and application of substantive laws by the arbitration tribunal. And the third, what I found is in some of the cases, there's a disregard or ignorance of clear and explicit provisions of the contract clause. And in some cases, they even went to the extent of inserting their own provisions as opposed to the clear and explicit terms and conditions of the contract. So indeed, some of the cases were appealed on the ground that the arbitration tribunal failed to consider the evidence submitted by the parties. And in some cases, the appointment of experts by the ADRC was flawed. So these are some of the common grounds why the parties prefer an appeal from arbitration tribunal to the High Court. Then moving on to the next question, how did the High Court decide on the appeal? So appeals for setting aside arbitral awards are treated, as I said earlier, like any other appeal against the decision of a trial court. In few cases, the High Court dismissed the appeal in accordance with ADR Act for the lack of jurisdiction to review the merit and substance of the arbitral award, but it's not consistent. And all these 14 cases are not reviewed by a single bench. It's reviewed by all three different benches. We have 3 benches in the High Court. So there are a couple of cases which were rightly dismissed based on section 150 of the ADR Act. But the reason they have stated is basically saying that the High Court, not because the grounds for setting aside the arbitral award was proved, but because the High Court concurred with the reasons given by the arbitration tribunal for its decision. So even in the cases where the appeal was dismissed, the High Court only dismissed after it was fully reviewed based on the merits and the substance of the award, not really on the grounds specified under the section 150 of the Act. And mostly upheld, not because parties could not prove, as I said, prove any of the grounds for setting aside the arbitrary award, but because the court concurred with the reasons given by the arbitration tribunal. Some cases are partially reversed, and few cases are fully reversed because the court did not agree with the interpretation and the reasoning of the arbitration tribunal. And one appeal was remanded to the arbitration tribunal. And I don't know whether this is in accordance with the Arbitration Act, because once the arbitration tribunal has rendered its decision, then it becomes defunct. Basically, it's officio functus immobile. So, which means once they have given their final and conclusive award, then it does not function anymore. So the next question is these decisions of the High Court consistent with the ADR Act? Both the process and the decision of the High Court is not inconsistent with the ADR Act, because the petition for setting aside an arbitral or must be treated differently as compared to the appeals that we receive from normal courts. It cannot be treated like any other appeal from the trial court. And because the appeal right under the CCPC is a blanket right, and it is guaranteed as a matter of right. So the appeal need not necessarily state any reason why the parties are appealing under the CCPC. So in case of petition to set aside arbitral award, the parties must make a sufficient allegations and prove any of the grounds for setting aside arbitrary awards, which is not done in any of the cases that I reviewed. And the court must also review the petition as per the ADR Act, not as per the general power of review, judicial review specified under the CCPC. So the review of the arbitral award must be confined to the grounds specified in section 150 of the ADR Act. And invocation of the High Court's power under section 153 of the Act must be limited to the specific grounds for setting aside arbitral award in section 150 of the Act. So if you remember section 153, which basically gives the High Court a review power once the decision of the arbitration tribunal is set aside, then the High Court has the full authority to determine the dispute in its own way. But I think it's a precondition that the High Court must set aside the decision of the High Court of the Arbitration Tribunal in accordance with the section 153, 150 of the Act. So, looking at the way High Court has decided or considered these appeals from the Arbitration Tribunal, it looks like they must have considered an appeal as a reference on the question of law. Of course, the ADR Act and the unscriptural model law does not specifically recognize this question, the appeal as a reference on question of law, but there are other jurisdictions like Malaysia and New Zealand where the Arbitration Act make a reference or gives the court power to review the decision of the arbitration tribunal based on the question of law. So basically, when the parties make a reference on a question of law, it is basically a point of law in controversy which requires an opinion, resolution, or determination by the courts. But this must happen prior to arbitration tribunal's final and conclusive award. So then, moving on to the next question, why did the High Court consider appeal against an arbitrary award like any other appeal from trial court? So I don't know, because I'm still in the process of looking for more information so that I'll substantiate my arguments, whatever I have put in my presentation. So basically, it looks like there are several reasons why High Court may have considered like any other appeal, because I think first, is it the arbitration tribunal that's responsible for so many appeals against the arbitration tribunal's decision? Is it the composition of the tribunal? So some of the questions that we need to consider is, do we need more legal experts sitting on the tribunal, and other experts like engineers, architects can assist the tribunal in the form of expert input? Most arbitral awards are not based on reasons, and some awards are even against the clear provision of the applicable laws. So therefore, do we need more capacity building programs? For example, in one of the award given by the arbitration tribunal, the claim of ideal charges for equipments and machineries is considered inadmissible contractually. Nevertheless, since the work was deferred and not delayed, the arbitration tribunal found that ideal charges for 12 months and 11 days are admissible. So if you look at the terms of the contract, it clearly states that the claim for ideal charges for equipment and machineries are not admissible. But nevertheless, the arbitration tribunal has awarded some damages for the claim made by the contractor. So therefore, is it the court which is assuming a moral responsibility to ensure that the terms of the contracts are effectively enforced? So the question that we also need to ask is, can the arbitration tribunal ignore the clear and express terms and conditions of the agreement and insert their own terms? Secondly, is it the court who is taking the moral responsibility by invoking the general power of judicial review? And will this not defeat the entire purpose of arbitration as an alternative method of dispute resolution? And third is it to ensure the proper check and balance on the arbitration tribunal's exercise of their power? Because if you look at the Arbitration Act, the grounds for setting aside is only based on the procedure and not really on the substance. So therefore, maybe the arbitration tribunals knows the weakness of the law. Maybe they knows that even if their award is not based on reason, then High Court basically doesn't have a review power to review their award based on the substance and merits. So therefore, maybe they are taking advantage of this weaknesses in the law. So therefore, to ensure proper check and balance, the court may have assumed the moral responsibility of reviewing the arbitration tribunals award law. And the fourth one is it the parties who are responsible for appeal against the decision of the arbitration tribunal? Because if you look at these cases, it's basically to do with payment of compensation or liquidated damages. So therefore, probably parties may be taking the advantage of the loopholes in the law, basically to buy more time or to delay the payment or to harass the other parties. So maybe we need to educate the parties, including the lawyers representing both the state and the private agencies. Or is it because the parties did not challenge the power of judicial review over an arbitration tribunal, and therefore the law in this field is not settled? So is it because, for example, if there is a case between MOWHS and contractor A, and if the contractor A is not satisfied with the arbitral award, then basically he appeals to the High Court. And if the representative of the MOWHS does not challenge the power of the High Court to review the award or decision of the arbitration tribunal based on the merits and substance, then basically the court, I think, will naturally assume the responsibility to review, invoking its general power of judicial review under CCPC. So therefore, if the authority or the limits, the role of the courts are challenged by the parties, then probably the High Court may have given a clear decision or ruling on to what extent the courts has the authority to interfere with the final and conclusive decision of the arbitration tribunal. So let me briefly walk through the consequences, the probable consequences. So on the one hand, we have this procedurally induced justice. So if we keep on continuing with what we are doing right now, then probably parties will be encouraged to appeal against the arbitral award, whether they are satisfied or not for anything, but to delay the process and harass the other parties. And secondly, there will be excessive interference from the court, which I think is antithesis to the fundamental concept of the ADR law. So the courts should not create an opportunity to convert the process from voluntary involuntary, which is also again antithesis to the very purpose of having arbitration as an alternative to formal litigation. So if we keep on doing what we are doing right now, then this process will become public to private, because I think the parties prefer arbitration because it's a confidential and it's a private process that they have voluntarily choose to resolve their dispute. But on the other hand, we cannot let the arbitration tribunal exercise excessive discretion to decide all these disputes at their whims just because the High Court cannot review the award on merit law. Because most of the cases that I reviewed involves public money law. For example, in most of the cases, the other party is MOWHS law. So there has to be a proper check and balance so that arbitrational tribunal is guided by the decision, or the making of the arbitrational award is guided by a reason and logic law. And I think the other consequences will automatically follow. So there will be undue delay in dispute resolution, and it will become costly, striking at the very foundation of the ADR law. And it will also lead to procedurally induced injustice, because the parties will take advantage of this loopholes in the law. And it will discourage the parties to opt for arbitration. And arbitration, I think, will become a matter of formality and not really a voluntary choice at the end of the day. So it will also defeat the whole purpose of ADR Act, ADR, the arbitration as a means of settling dispute amicably. And finally, we'll have losing the ADRC. Will lose the public trust and confidence. The people will not choose arbitration as a means of dispute resolution. Rather, I think they will choose court as a forum to resolve their dispute. And I think effective arbitration system is a key to foreign direct investment law. So if you look at draft 21st century economic roadmap, it strongly suggests that, despite the fact that arbitration has so many advantages over formal litigations, people still do not prefer arbitration as a method of resolving their dispute. Rather, they are happy to go to the court, even if they have to spend a lot of time and money on litigating law. So, in conclusion, I'd like to say that arbitration-friendly pro-recognition and enforcement and arbitration-efficient courts are indispensable for ADRC to achieve its intended aims and objectives. So the journey of ADR's mission to becoming one of the premier arbitration centers in the region must begin at home. So therefore, we must ensure that there is a correct balance between the exercise of power by arbitration tribunal on one hand, and the exercise of review power by the High Court on the other hand. So I can see that there are huge potential for ADRC to contribute to the nation's economic growth, but there has to be a proper dialogue between the ADRC and the judiciary to constantly improve the ADR system, which is a necessary precondition for building an efficient and robust arbitration system. So in short, this is what I thought about all these cases that were decided by the arbitration tribunal and then went to the appeal to the High Court. Thank you.
Yes, thank you, Latashu, for giving your valuable insights on issues and challenges on setting aside arbitral awards by the court, and also how our arbitral award appeals are dealt with by our courts. As we all know, I think it's a settled law in many jurisdictions that courts should not interfere with the awards merely because an alternative view on the facts or interpretation of contract exists. Court judgments of these jurisdictions, I think, have constantly held, especially the Supreme Court judgments have constantly held that court should not be interfering with the views taken by the arbitral tribunals in Navala, unless, of course, it falls under the conditions mentioned in the given in the Act, like Section 150 of our ADRC Act. But then again, in these jurisdictions also, I think the discussions are happening whether parties should resort to arbitration as a dispute mechanism, as the only dispute mechanism, or whether the courts, if they are if they get any arbitral awards, should they interfere with the arbitral awards at all? And I guess Bhutan is no exceptions, and as mentioned by Trungpan Tenzin, I think we have a lot of opportunity and potential to improve the system and the process in Navala. So thank you, Tasho, for that. Next, we have Mr. Tandin Doji, who will present about the public procurement rules and regulations in Bhutan. So Tandin is a senior legal officer at Procurement Management and Development Division, PPMD, under Department of National Properties, Ministry of Finance, where he carries out sensitization and awareness programs on procurement rules and regulations and related documents to government budgetary bodies, contractors, suppliers, service providers, and other relevant stakeholders. Some of his daily talks involve providing legal advice on PRR and related documents and reviewing appeals relating to procurement to the government. He's a member secretary to the Independent Review Body and Debarment Committee, a member of the Task Force Drafting of Construction Policy and Bill, and a focal person for the award of repair and maintenance works to specialized firms for the Bhutan Build project. Since early 2020, he has taken the lead role in drafting and issuing simplified procurement rules and regulations 2020 and 2021, along with drafting and giving various notifications to address the COVID-19 issues relating to public procurement. He was a member of the multi-sectoral task force for the procurement reform, which included modernizing public procurement. He was also involved in the development and enhancement of EGP. Before joining PPMD, he served as a legal officer for Shemgang Dzongkhag. He holds a Bachelor's of Law from Nalsar University, India, and a postgraduate diploma in national law from the Royal Institute of Management. Tandin, you have the floor.
Yes, thank you, ma'am. So I'd like to directly move on to my presentation. So I hope I'll be able to do justice in the next 15 minutes as I take over the existing procurement rules and regulations of Bhutan Session Email. So to give a brief background on the existing procurement rules and regulations. So like, if we look at the journey of public procurement in Bhutan, we have come a very long way. So it was only in back in 1988, there was only a particular procurement section under the financial manual. And only in 1999, a separate procurement manual was included in the financial manual. And it was only in 2006 that the first procurement cadre was created under RCSC. So generally, and as we look through, when we look at the agencies, it's only the procurement is taken as an administrative task and not as an professional membership. It's always treated as an administrative task, and that has always been one challenge. So in 2006, the procurement cadre was created under RCSC, and then the back then, now PMDT back then it was called as Triple PT Procurement Policy and Development Division. So the Triple PD was established only then in 2008. And then once the Triple PT was established, then the procurement rules and then the standard bidding documents were first drafted in 2009. And then until 2019, as in apart from, of course, minor amendments being issued and minor revisions, no major reforms in the procurement system was done. And in 2019, with the objective to modernize public procurement, a major reforms in the procurement policy took place then. So of course, the legal mandate that if we, of course, the Dutch Secretary has clearly explained on the Article 14, Section 5, so where the government is mandated to exercise proper management of monetary system and public finance. So where public finance also includes procurement. And in particular, the main legal basis where we draw our authority right now is from Section 104 of the Public Finance Act. So that particular section.
Tandin, sorry. Tandin, sorry, can you scroll your slides? We can only see the first slide. I'm so sorry for.
Okay.
Just a second, but yeah, I think there is an issue. Okay. Tom Mela, can you please go to the next slide to just check if it is working properly?
Is it working?
아니 단지 저기 리쉐어 배고 들어 아니 미투 스탑에 왔노.
Yes.
두배다 듣지.
Is it visible now?
Yes, Latandin, it is now.
So Section 104 of the Public Finance Act, that's the main legal basis for our existing procurement rules and regulations. So that particular Section 104, it empowers the Minister of Finance to issue rules and manuals, directives, and issue notifications on procurement systems which is equitable, transparent, competitive, and cost-effective. So based on these four principles, we have our procurement rules and regulations. So our procurement rules and regulations are basically based on these four main objectives. Firstly, to ensure transparency through clear processes. Then secondly, to achieve uniformity through the clear processes which has been prescribed in the procurement rules and the standard bidding documents. Thirdly, to achieve economic efficiency, and then fourthly, for the fair and equal access to the suppliers and the bidders. And in addition, as Madam has already mentioned earlier, since the pandemic began, we drafted something called the Simplified Procurement Rules and Regulations. So the main purpose behind having the SPR was that most of the agencies, as the pandemic began, most of the government started front loading all the capital activities, and then most of the concerns raised by the agencies were that the normal turnaround time taken by the timeline prescribed in the PR was really long, Sela. So if they had to do open bidding, it would almost take 90 days to award the contracts, Sela. So 30 days to send the invitation, then 30 days to evaluate the bids, and then until the awards could be made, it almost took 3 months. These were some of the concerns shared. So to address all these issues, we then drafted the simplified procurement rules and regulations, which actually we have tried to provide as much flexibility as possible under the SPRR. Then, of course, the PR, it applies to all the government budgetary bodies, including the armed forces. However, there are certain exceptions. So like the basic security of the state. So like buying some sensitive procurement, such procurement can be excluded. Secondly, donor-funded projects. So if a particular project is funded by, let's say, World Bank or ADB, then generally there is a donor funding agreement. So if the agreement says that the World Bank procurement document would be adopted, or else ADPK procurement document would apply, so then our PR is then not applied there. Thirdly, for corporations, so even the DHI and then BPC and all those corporations, they're exempted from using the PR. So if approved by their board of directors, they are allowed to come up with their own rules and regulations. And of course, there are other exceptions, deposit works. So deposit works, if the works of specialized nature basically means that if a particular, if our local contractors and local suppliers do not have the capacity to execute a particular work, then such works can be actually treated as a specialized work and then executed departmentally. And moreover, emergency situations are also defined under the procurement rules and regulations. So it's not necessary that all the tendering process has to go through the open tendering method. So if there's an emergency, let's say the pandemic had begun. So when the pandemic started, Ministry of Health had to procure a lot of medical COVID related items. So because of the emergency, they did not have to follow the normal procurement process. Treating it as an emergency, they could then bypass all of the procurement processes and then choose for the best method of procurement. And similarly, procurement of items. Yesterday, there was a talk on this central procurement and procurement of common use items. So this is already an initiative which DNP has already taken. So we have identified certain commonly used items so that this has been procured centrally. The whole tendering process is done by DNP, and then the agencies just have to put a requisition and directly buy it from the supplier. And likewise, even for HTP pipes and cements, basically to promote our local industries and as in the revenue generation avenue, such initiatives have been taken. And for information, one of the recent initiatives was the central procurement of laptops and computers. So this is again an initiative that DNP has recently taken. So basically, if we look at the procurement cycle, it begins with the planning, then the budgeting, the market research, sourcing, the annual procurement plan, the actual procurement, and the contract management. So even if we look at the definition of procurement, it does not end as you buy a particular thing or as you finish construction. That's not the end of procurement. There's the whole life cycle. Begins with the identification of needs, and it goes until the disposal of the assets. So that's the whole of procurement cycle. And moreover, Khata RA has clearly pointed out some of the issues, particularly pertaining to not having done proper planning, then lack of market research and analysis, need identification. So based on all this, the recommendations from we have now made included mandatory provisions in the procurement rules and regulations. So they are mandated to prepare annual procurement plans. Then they're, if based on the nature of procurement, they have to carry market research and identification of needs. So all these are basically to address proper utilization of resources.
Tandin, sorry again, we need, sorry to interrupt you again, but I think it looks like we will share the presentation from here. Like, Pale at the Ani Kajalo. I think it's getting stuck and then Ani slide the run me beva. So I think we'll try and do it from our end. So can you tell us, Kajalo, whenever we need to change the slides? Thank you, Tandin. Which slide number are we on right now?
Next, it's Marin. Next. Next. So this one I can go back. So on the organization of procurement, based on the structure of comment, these are the different levels of tender committee. Starts with pure tender committee, then for basically for we have under the procurement rules and regulations, we have tried to cover all the different structures of government and then come up with the respective thresholds. But however, for kind information, Kili sir was mentioning that government threshold do. So just for kind information, now these thresholds have been lifted under the simplified procurement rules and regulations. So now the respective tender committees, irrespective of the threshold, have the full authority to decide on their procurement matters. However, for department and ministerial tender committee, we have retained as it is, because since they fall under the same umbrella, so on hierarchy, we have retained that. But otherwise, rest of the thresholds have been lifted. Next. So under the existing procurement processes under RGOP, basically there are 3 levels of tender committee: the tender opening committee, the tender evaluation committee, and the tender committee. So the opening committee is with the starting of with the EGP in place. The opening committee is more or less redundant. Then the EGP system auto generates the report, and then Hemazumbe, like before the meeting Jablo and some Kachepeko message. However, the next then we have the tender evaluation committee basically carries out evaluation, and then the tender committee. So tender committee is basically the decision making committee, the monitoring committee, then the contract implementation committee is the tender committee. So tender committee, if we look at the powers and responsibilities of the tender committee, our PR clearly says that the following are the roles and responsibilities of the tender committee, but not limited to. That particular word is there, but not limited to something. But the current challenge, what we currently face, is that the tender committees do not want to go beyond the powers and responsibilities prescribed in the PRR. With that very reason, now we have put an additional clause in the SPRR. So we are now clearly saying that the respective tender committees are the competent authorities, and they have the power vested in making any procurement decisions beyond the responsibilities and powers prescribed in the PRR, having exercised due diligence and best of their judgment. So basically, we are now terming this, clearly defining them as the competent authority, and in case they have to make any decision, they can exercise due diligence, and having used best of their judgment, they can issue, they can take decisions. Next. Then we have the tender evaluation committee. So basically the evaluation committee, their main mandate is to carry out the evaluation, but as such, they do not have any decision-making powers. Once they have, they're done with the evaluation, they're supposed to present the evaluation report to the tender committee. So the tender committee would then basically take the decision. However, the tender evaluation committee, while evaluating, should evaluate based on the preset criteria, because we have, in past, we have had issues where evaluation committee members try to bring in new evaluation criteria, but actually looking at it, that is actually very discriminatory email if they try to bring in new criteria. So that's not allowed session email. Next. Next. Next slide. So these are the methods of procurement. Agents in the procuring agencies, while carrying out procurement, they adopt these methods of procurement. So the open tendering method, it's the basic method of procurement. Then for each method of procurement, there are respective methods of procurement, there are thresholds. So it's not mandatory that first intermediate people feel that they have to go for open tendering only then the other methods of tendering, but that's not true. For each method of procurement, there are different thresholds, there are different conditions. So as long as you fulfill the thresholds, as long as you fulfill the conditions, you can directly adopt those methods of procurement. And the even direct contracting method. That is, agencies are very hesitant to adopt the direct contracting method. But if we clearly look at the provisions in the PRR, there are 8 conditions. And firstly, there's no threshold under direct contracting method. People feel that there are threshold. So there's no threshold under direct contracting method. There are about 8 conditions. So as long as any of the 8 conditions are fulfilled, they can directly adopt the direct contracting method. And further, these provisions for the direct contracting method, the conditions have been further simplified. And like someone mentioned, we also have the framework contracting. So generally it's known as annual quotation. So based on a need basis, on an interval basis, as and when you require it, you can issue supply order and then procure those goods. Next. So this is a comparison between the PR and SPR. So just to quickly run through. So the open tendering method. So under the PR, if the agency had to follow the open tendering method, if the value of the procurement was more than 4 lakhs, they had to go for open tendering method. But under SPR, this sorry, I think I haven't corrected it here. But under SPR, this has been increased to 1 million. So if the value of procurement for goods is more than 1 million, they have to go for open tendering. But if it's less than 1 million, then there's the limited tendering and limited inquiry method. Actually, these are 2 methods of procurement under PR, but under SPR, these 2 methods of procurement have been clubbed and made as 1 method of procurement. And likewise, the bid submission dates have been reduced from 30 days to 10 days under the SPR. And likewise, for LTM and LM methods, it has been reduced to 3 days. So overall, if we look at the total turnaround reduction in terms of percentage, we have almost reduced it by almost 75%. And then the standstill period. So standstill period is basically once the agency is done with the evaluation and issues the letter of intent. Then as per PR, there had to be 10 days. So within the 10 days, if there were any grievances, it had to be submitted within this 10 days. But this has also been now reduced to 2 working days. And likewise for the contract signing, earlier, as per PR, 15 working days was given for the one contractor or the supplier to sign the contract and furnish the performance security. But this has also been reduced to 5 working days. And moreover, apart from the other flexibilities in the direct contracting conditions, we have agencies can actually now award works up to 10 million directly to a particular contractor. Of course, there are other conditions that need to be fulfilled. And likewise, procurement of goods under COVID-19 situation with extremely tight deadlines are also treated as an emergency, and this can be procured following the direct contracting method. Next. So, of course, the procurement rules and regulations it's the mother document. But while actually carrying out the procurement, it is done using these standard bidding documents. So standard bidding documents, we have standard bidding documents for goods, we have standard bidding documents for works and then services lah. So again, based on the threshold, we have different types of standard bidding documents. So these standard bidding documents are then based on the nature of the procurement. The agencies would modify these standard bidding documents to best suit their project and then carry out their procurement. Next. So I would like to go through some of the, I think, provisions that terminologies that we have in the procurement rules and regulations. So we have the bid security. So bid security basically ensures that the bidders would not withdraw their bids once they submit their bids. In case they are awarded the work, they would sign the contracts and furnish performance security. This is an assurance. So for large works and large supplies, bid securities are mandatory. But for small contractors and small suppliers, we have something called the bid securing declaration. So this is basically to ease the financial burden on the small contractors and small suppliers. So they don't have to furnish bid security in terms of monetary value, but instead they are only required to sign an undertaking. Basically, however, the terms and conditions are more or less like the bid security situation. Next. Then use of brand names. So the procurement rules and regulations actually does not restrict mentioning of brands. It said that suppose you are mentioning one brand, let's say Dell, then or their equivalent Semichi, that had to be followed by after the brand name situation. But with all the having consulted all the agencies and all the relevant stakeholders, now we are taking a different approach. Now we are saying that having carried out thorough market research and need analysis, now the agencies can at least specify 2 brands. So that this is basically to provide more flexibility to the agencies. Likewise, pre-bid meeting is an option right now. But under the SPR, we have made the pre-bid mandatory. So for procurement works above 50 million, for goods above 10 million, and for services above 5 million, we are making the pre-bid mandatory. So based on best practices around the world, they say that if the pre-bid meeting is conducted, this is an avenue whereby most of the pre-procurement related and actually issues related to the procurement process can be resolved. That's why we are making it mandatory. Next. Then evaluation. Now this is another major issue. If we look at the procurement rules and regulations, it clearly says that price is only one factor. So this basically means that there are other conditions, there are other eligibility criteria, qualification criteria, terms and conditions, the technical specifications. So taking all these into consideration, the lowest evaluated bid should have been determined. It says lowest evaluated bid, not lowest price bid. However, with the based on having conducted so much of awareness, so much of consultations, we thought that there's some mistake in the terminology itself. That is why now we have termed it as best evaluated bid. So basically to say that price is only one criteria. Next. Next. And this is another major issue in the procurement works. So what the contractors, they tend to do is to get works. They tend to quote really low. In fact, they go to the extent of quoting 20%, 30%, 40% below the departmental estimate. So to address such abnormally low bids, we have now we have a clear process in place. So if the bids are below 20% below the departmental estimate, then it is treated as an abnormally low bid. Then the evaluation committee, they're supposed to review their departmental estimate, because again, in most cases, the agency departmental estimate itself is not realistic. So basically, to ensure that your departmental estimate is realistic, you're supposed to review it. Once you're done with the reviewing and you're satisfied that it's realistic, then you are supposed to seek rate analysis from the particular contractor. So based on the rate analysis provided by the contractor, if the evaluation committee is convinced that works can be executed even though his rate is abnormally low, so it can be accepted. But if the rate analysis provided fails to demonstrate its ability to or if it's not realistic, then the evaluation committee has the authority to reject the best decision. So these are the mechanisms in place. It's not necessary that the lowest financial bid has to be awarded the work session. Next. I'll take another 5 minutes. And on the dispute resolution front, so dispute resolution can be seen in two stages. First, the pre-award stage. Pre-award stage means still the award of contracts. And the second is during the contract implementation. So during the pre-award stage, and even for the contract implementation phase, first, the tender committee is supposed to act as the first tier grievance redressal body. So be it pre-award or during contract implementation, the tender committee is responsible for amicably settling the disputes if possible. But however, during the pre-award, if the tender committee fails to resolve the disputes, then it is appealed to the independent review body. So if the independent review body is a 7-member body comprising of members from both government and private agencies, and PMDD, our office, is the secretary to the independent review body. So they carry out independent review of the cases. And during the contract implementation, of course, again, the tender committee is supposed to act as the first tier grievance redressal. And in case the dispute is not resolved, then it is appealed to, it can be arbitration or it can be court. So it's based on the contract agreement. It can be either appealed to the arbitration or it can be either appealed to the court. Next. Next slide. Skip this. Okay, next time. And on the payment of bills, generally contractors and suppliers, they share concerns that agencies are taking too long to clear their bills. Concerns raised by Dula. So now under SPR, of course, there were provisions in the earlier documents as well, but under SPR, we are clearly mentioning that for works, now payment has to be made within 25 days. So the engineer has 15 days to verify, and the finance has 10 days to make the payments. Likewise, for procurement of goods, we're saying that payment and services, payment has to be made within 15 days. In case there's delay in payment, the particular individual from where the delay has gone would be accountable. Next. So likewise, we have provisions for liquidated damages and defect liability period. So the liquidated damages are generally imposed between 0.05 to 0.1%. So it can be between this range, and it is imposed on a daily basis till once the intended completion date is expires, and it goes up to a maximum of 10% of the contract price. And likewise, defect liability period, our procurement rules and regulations only prescribes the minimum period. Minimum is 12 months. So the maximum, based on the nature of the project, the complexity of the project, the agencies can prescribe in their contract documents. Next. So under consultancy services, so basically these are, we have the individual consultancy and then firm consultancy, and these are the different methods of procurement. And another misconception is that people say that while adopting consultancy services, they want to do it following open tendering method, limited tendering method, which is wrong. For consultancy services, we have separate methods of procurement, like the QCBS, fixed budget law, least cost law, single source law. So these are the methods that should be adopted while following the consultancy services. And we, of course, yesterday audit was raising concerns on not having liability on the contractors, and likewise, so I would like to share that we have provisions for professional liability under the bidding documents, but this is not been implemented by most of the agencies. So we would like to reassure that we make sure that these provisions are reinforced and put in place. Next. So this is my last slide. Oh, sorry. There's supposed to be last slide. So basically, last slide, it's implementation timeline. I have 4 things to share. The first is on the SPR 2021. So we, as per our plan, we implemented it by 2nd November 2021. Second initiative we have is the procurement of works. So we are currently reviewing the existing procurement key evaluation parameters. So like yesterday, there was a discussion on only the financial bits been taken into consideration. So now we would like to inform everyone that this has been reviewed, and particularly for large contractors and medium contractors, we are reviewing the evaluation parameter, and then now we would have a carry forward of 30 points, technical 30 points would be carry forward. Once a contractor is technically qualified, there was no carry forward of points. Now we would be carrying forward 30 technical points, and then 70% would be of financial score would be taken into consideration. And thirdly, overall procurement reform is also underway. So we have a Singaporean consultant who's working on it. So we are hoping that by March 2020, April this year, they would submit their report, and then accordingly, then we would implement Sishunivela. And fourthly, the fourth initiative we have is the EGP. So EGP has come a long way since 2017. So the third phase of EGP, we are hopeful that by 2023, the whole of the procurement process, starting from the bidding process till the contract disposal, would till the contract end of contract management payment, all would be covered under the EGP system. Thank you. Sorry for taking long.
Thank you, Latanjin. Thank you for your presentation and enlightening us with the different aspects of public procurement rules and regulations. I think it's historical development, and also the progress that the department is making with regard to public procurement here in Bhutan. Many of the informations that you shared during your presentation, I'll be very honest, is very new to me, and I'm sure it is to many of the other listeners also. So thank you for sharing about the public procurement rules and regulations here in Bhutan. Thank you, Tandin. Now, finally, we have Professor Rachel and Sheila to present on the interaction between competition policy and public procurement policy. In their presentation, they will introduce competition law and how it interacts with public procurement by focusing on bid rigging. And their presentation will also very briefly mention the impacts of COVID-19 on procurement policy and tips for advocacy and competition law and the harm of bid rigging. Professor Rachel is a law lecturer, consultant, and researcher with extensive experience in the UK, Europe, and the Asia Pacific region. Rachel practiced as a lawyer in Australia and the UK for more than 10 years, specializing in competition law. From 2010 to 2015, Professor Rachel lived in Malaysia, where she worked with the then newly formed Malaysian Competition Commission. Since then, Professor Rachel's passion for ASEAN competition law has seen her conduct bilateral and multilateral capacity building and technical assistance programs throughout the region. Exciting recent projects include research on role of competition law and policy in COVID-19 recovery and developing the ASEAN Regional Capacity Building Roadmap 2021-25. Professor Rachel has spoken at various conferences and published widely on competition law and policy, emphasizing the developing countries. She recently published her first book, The Philippine Competition Act Annotated, which she co-authored with former PCC Commissioner Amabel Asuncion. And then we have Ms. Sheila Dorai Raj, who is currently an executive director at Vansur Consulting Sindh. Forgive me, Sheila, if I'm pronouncing that wrong. Sheila was the founding CEO for the Malaysian Competition Commission. With a career of 33 years in the civil service, she has a deep understanding and expertise in developing policy issues, formulating and implementing competition policy, consumerism, and trade, both domestic and international. She was the Undersecretary at the Ministry of Domestic Trade, cooperative, and consumerism, overseeing the policy of the ministry, which included consumerism, intellectual property rights, and domestic trade policies. She was also involved in drafting several policy papers to support the passage of the competition policy of Malaysia and helmed the drafting committee for the Competition Law 2010. She has represented Malaysia in numerous international, regional, and national level conferences, seminars, and workshops. She has a certificate in legal practice from University Malaya, an LLB Honours, University of London, and BSc Economics from University Kebangsaan, Malaysia. Thank you, Professor Rachel and Sheila, and now the floor is yours.
Good afternoon, everyone from Brisbane, Queensland in Australia. It's afternoon here, but I know it's morning there in Bhutan. Thank you very much to JSW Law for organising this conference. Sheila and I will present our paper today, which looks at the interaction between competition law and public procurement. We know that this is a public procurement conference, and we're very grateful to our co-presenters for some really insightful discussion so far already on the procurement rules. We're going to take it on a slightly different road now and have a look at the interaction with competition policy. I'll start off and then hand over to Sheila, who's going to look more closely at the role of advocating for competition policy in the context of public procurement. So the first question that I wanted to address for you is how is competition policy relevant to public procurement? We're very conscious that competition policy is a new policy, relatively new for Bhutan. And so we thought we would be helpful for you to give you a little bit of the basics of competition policy before embarking on the interaction with public procurement policy. What you will see in competition policies around the world is that what it's designed to do is try to ensure a competitive marketplace. And it does that by trying to level the playing field so that all participants who want to participate in a relevant market have an equal opportunity to do so. The way in which it ensures a competitive market generally is for competition policy to prohibit three types of behaviours. The first one is anti-competitive agreements, usually both horizontal agreements, that's agreements between competitors in the market, and often also prohibiting anti-competitive vertical agreements, and that's agreements that are in place between parties that don't compete. So an example might be the manufacturer and the distributor. They clearly don't compete in the market, but sometimes the agreements between them do have an effect in the market. The second type of behaviour that competition policy generally prohibits is abuses of dominant position. Big players have a particular responsibility in the market to behave fairly so that other smaller players can also participate in that market. And finally, competition laws also generally prohibit anti-competitive mergers and acquisitions. And that is because an anti-competitive merger might result in a particularly large player that really distorts the competition in the market and leaves not much choice left for consumers. Cartels are considered the most serious breach of competition law. Now, a cartel is a horizontal agreement, so an agreement between competitors. And there are four recognised types of cartels. The first one is a price fixing agreement where competitors agree the price at which goods or services will be sold or provided. The second one is a market sharing agreement where the market is cut up and shared out between competitors so that two players are not competing for the same customers. The third type of cartel is where those competitors agree to limit the amount of goods or services they produce or supply, because that then results in a shortage, which could puts upward pressure on price. And finally, and most relevant to this discussion, is the prohibition against bid rigging. And I'll explain bid rigging a little bit more in a minute. What our paper also discusses is the inevitable overlap between bid rigging and corruption. We're not going to have time to talk about that today, but certainly we've covered it in the paper. And there is often, because of the role of government in the procurement, there can be situations where both the rules against corruption and the rules against competition law may overlap. So bid rigging, to give you a little bit more information about bid rigging can occur in a number of different ways. Cover pricing is a very common way for bid rigging to take place. It involves the scenario where I effectively put in a fake price for a bid. I might put in a price that's substantially higher than what I know Sheila is going to price. And in that way, we assure that Sheila wins that work. For the government organisation that's running the bid, it looks as though there's a competitive market. It looks as though I've put a bid in and Sheila's put a bid in, but really there's no competition in that bidding process, because Sheila and I have already agreed the prices that we will bid at. Similarly, there's bid suppression is a way to achieve a bid rigging offence, where Sheila might agree not to bid for a particular project. Bid rotation is, as the name suggests, where Sheila and I might take turns to win a bid. And there might be market allocation, where I agree to put in the bids for a particular geographic area, and Sheila agrees that she will only bid for work in a different geographic area. The presentation on bid rigging brought to mind the opportunities for procurers, government procurers, to be looking for signs of these bid rigging processes when they're doing the evaluation of bids. It's probably something that warrants another discussion on its own, but worth us thinking some more about in due course. I have a couple of case examples for you. The first one involved a bid for services at various wildlife reserves around Singapore. This case was brought by the Competition and Consumer Commission in Singapore. And what's most interesting about it was that the government department itself identified the bid rigging. There was consistencies in the bids that were submitted. There was lots of things the same across the bids that were submitted, which prompted wildlife reserves themselves to go to the Competition and Consumer Commission and say, we think there's something not quite right here. And that resulted in the CCCS investigation. There's also a relatively recent case in Malaysia involving IT services, where 8 companies were found to have cooperated in relation to the tenders to provide IT services. And they had actually shared ahead of time the requests for quote, they'd shared their own tender proposals, and they'd manipulated the prices between themselves. And they also prepared documents for each other. And that's often the way that you can detect cooperation, is because those documents look consistent. In that particular bid rigging arrangement, the winner of the bid agreed to share the profits with the losing bidders. And that's often a common compensation for anyone willing to submit a bid that they know that they're not going to win. We said we'd just mention COVID-19 very quickly. Obviously, there has been increased pressure on governments during the COVID pandemic to procure goods urgently, and often in much increased volumes. So that may have driven governments to use or rely more heavily on sole supply either because there are fewer suppliers available to supply the goods that have the stock or the capacity to meet the requirement. And it may simply be harder to run a competition where there's fewer suppliers and greater time pressure. For those of you who'd like to have a look at it, the OECD published a short document during the pandemic entitled COVID-19 Competition and Emergency Procurement. And it sets out some interesting guidance there for procurers as to how they might minimise the use of sole supply even during a pandemic. So it suggests things like considering whether an existing arrangement could simply be renewed or extended, assuming it assumes, of course, that that existing arrangement might already have been completed. It also suggests that even if you're short of time, consider whether there is an appropriate fast track competitive procedure that could be used in your jurisdiction. So there are some interesting tips available there if you're interested. Bid rigging creates a lot of harm to society. The OECD quotes 20% increases in government expenditure as a result of bid rigging. And ultimately, of course, it's the taxpayer that pays for those increased costs. There are some really good examples and campaigns that have been run recently by the UK Competition Markets Authority, the CMA, and also a really useful little, it's about a 10-minute video from the OECD on what is the harm to bid rigging. So if anyone, unfortunately, we don't have time to see it today, but if anyone is interested, that is certainly interesting for you to watch. I'll hand over to Sheila, but the last point I'd like to make before I do is we actually had a warning issued here in Australia November last year from our chair of the Australian Competition and Consumer Commission, who actually said publicly to government departments that they needed to be very careful about bid rigging and that they needed to be very clear that a competition was expected. And he made the point that cartels can sometimes start with a small encouragement or an innocent remark, but that can create an environment that enables, condones or facilitates collusive conduct between competing firms. So here in Australia, they've come down very hard recently, again, on bid rigging in public procurement context. On that note, I'll hand over to Sheila to discuss the advocacy angle for procurement and competition policy. Thanks, Sheila.
Thank you, Rachel. Can you hear me?
Yes.
Yes. All right. Thank you. Thank you, organizers, for including us into this very interesting discussion. Full country wished, that it could have happened, there. All right. So the next slide, we will talk about the advocacy, because there's the last speaker, Tenzin, actually gave us a lot of very interesting information about the new procurement policies. And, this is something that I think the stakeholders in Bhutan would have to know in detail, because it's a very useful piece. It contained a lot of useful information, and it actually, would require a lot of effort to ensure that your stakeholders actually understand the processes. And with Rachel's presentation, the implications, when there are any signs of bid rigging. So an important issue that your agency would have to actually undertake it to advocate to your stakeholders why this issue is really important in the context of competition law in your country. Resources in terms of not only personnel, but also, the finances. So where do we start? Who do we advocate to, why and what? So basically, definitely your key stakeholders would be your Ministry of Finance, because that's where your government procurement policy resides. And of course, other government procurement divisions within within other institutions and agencies of the government, as well as, those which are outside of the central government. And businesses, they would have to know that, what are the implications if they are involved in bid rigging. Actually, some of them can actually help you to detect, if they are working hand in hand with the competition agency, they would be able to help the agency, or they would be able to tip off the agency on, which cartels are in existence and which businesses are actually be also the ears and eyes of your government and the media, because the media plays a very important role. They would actually highlight in the press or in any social media platforms what is bid rigging, how can the public assist the government in detecting bid rigging, and what should actually be the role of government servants when dealing with public procurement issues. Next. So why? I think we've heard quite clearly, and actually Rachel also mentioned that, the OECD has estimated that elimination of bid rigging could help reduce procurement prices by 20% or more. So can you imagine, the government is able to save that amount of money. And because public procurement accounts for 60% of government budget, this of course, plays a very important indicator of why, you should seriously. So it is important for stakeholders to understand the importance of a competitive procurement process. A lot of people sometimes think that government awards contract on a direct negotiation basis. Some, as Tenzin pointed out, that you can actually get involved in a direct negotiation, but there are certain criteria that will have to be adhered to. And but basically, when I looked at your documents, I understood that the government wants a really competitive procurement process, and it's also important for them to understand the rules and implications if there's an involvement in bid rigging. So as I said earlier, the National Competition Policy of your 2020, it prohibits bid rigging. And of course, it encourages a competitive bidding system. And that actually supports a transparent and a non-discriminatory procurement system. And I think, it's I'm really happy to see that, you're starting off on a very positive in your country. Next. So what do you advocate? So the OECD has a library of materials, and you can actually go into their website and you can, the agency actually involved in this would be actually the competition agency as well as the Ministry of Finance, and you can actually both work together and use the materials available on the OECD as a reference for your advocacy sessions. Detecting bid rigging in public procurement, helping governments to obtain best value for money. These are some of the documents that I just picked out for you. And other international agencies, the ICN, the UNCTAD, and other actually regional agencies like in the Asia Pacific, you have Korea, you have Japan, they have all very long involvement in competition, not Hong Kong in competition law, but and they also have a lot of materials that you can use for your guide. We would encourage you to look at implications of bid rigging on government and public. And if you have some scientific data, because usually, evidence-based advocacy is more useful than just talking out without any evidence to support what you have to say. And how to detect it, like for example, those government servants who are involved in the procurement process, you would have to train them as to identify, what are the issues that they need to look out for, and how, enable them to enable them to identify and detect, that there's a bid rigging scheme somewhere. And also who to reach out to if detected. So if the government procurement officers are able to detect and identify some discrepancies in your procurement processes, who can they reach out to? So you have to make all these and how do you convey the message? So there are various ways that you can actually cascade these messages out to your stakeholders. Firstly, you need to conduct your training for your procurement officers at different levels. Basically, you would start with the Ministry of Finance, or where the procurement policy resides, and then you cascade it down to, the different levels of procurement officers, and then go out to your agencies and, your state level officers. And as I said, use real life examples. They are available online at the OECD websites or other Asia Pacific competition agencies. So you bring those real life agencies back to a real a situation in your country, and you would be able to relate. Your stakeholders will be able to relate more better. And I always think that training colleges and public service training institutes are the best conduit to be used, to on bid rigging. And I mentioned earlier that your media tools are also an effective way of conveying message. So it'll be best for you to also engage the media people and train them and give them sufficient information so that they are able to be your conveyor of messages. Next. So these are some of the guidelines and recommendations that Rachel and I thought that we could, share with you. And I'm sure you have addressed some of these issues, that the procurement documents must contain clauses which warn about bid rigging and its consequences. So I think in Malaysia, we have those kind of clauses already in our procurement documents. So it is, those who are caught bid rigging cannot deny the fact that, they did not know that, that it is an offense. And prepare materials in the form of leaflets, brochures, simple language in 1 or 2 pages, with some how to detect it, because sometimes when you use legal language, not all your stakeholders are legal people, so you need to use some simple language and illustrations to ensure that they understand. And where the opportunities arise, talk about bid rigging, whatever conferences that you may have or whatever seminars that you have or meetings, try to bring this issue up so that, it is talked about and people begin to understand what bid rigging is and its adverse effects and, how Bhutan can address it. And again, I'm emphasizing that please work with the media on spreading information, because they are the best source of, people who can convey the messages for you. And of course, you will need to build cooperation arrangements between your government agencies, example, your Office of Consumer Protection, the MOF, the Anti-Corruption Commission. So cooperation agreements work very well, and they've worked very well for a lot of the countries in the Asia Pacific region. So, and I'm sure Bhutan is also not only with the government agencies, but also outside of Bhutan. And I think that would be the last slide. Thank you. So I'm not sure whether we have any time for questions, but over to the moderator. Thank you.
Thank you, Professor Rachel and Sheila. Thank you for your very informative presentation, especially on the competition policy. And I'm sure it was for the officials from Office of Consumer Protection, Ministry of Finance, and the other relevant agencies who are here today, because as you mentioned in your slide, it is a new policy area here in Bhutan. And we have a competition policy 2020, but it's in it is in its nascent stage, and we are yet to fully implement it. And therefore, the advocacy strategies and all of that you've provided in your recommendation slide will be very useful for Bhutan. So thank you very much for that. And with that, I want to thank all the 4 panelists for your presentation. We are out of time, but we have two questions from the audience to Dr. Tenzin and Tandin. So I think I will sort of read out the question to Dr. Tenzin and to Tandin, if you could very briefly answer to the two questions that we have from the audience. To Dr. Tenzin, you've discussed about the requirement of the proper dialogue between ADR and judiciary to build efficient and robust ADR system. What would be your advice to ADR and judiciary to avoid foreign company like BHEL taking MHPA to Delhi High Court, directly filing a case in their country, despite choosing Bhutan's ADRC for dispute resolution? This is a question from Kili Gelsung Infra to Dr. Tenzin. And then we have a question to Tandin from Kile Gelson again. What are the alternatives available under Bhutan procurement law to engage the best and reputed companies who do not want to follow our standard PRR? These are the two questions. Like, if you could very briefly answer to these two questions. Thank you.
Asla, thank you, Kilisa, for the question. Technically, I don't know the details of MHP's keys, but technically, I don't think you can file a parallel keys in other jurisdiction once you have clearly stipulated in your contract that, or once the parties has made a forum of choice of their forum. So if in their contract, if they have chosen ADRC in Bhutan as a seat of arbitration, then probably I think they have no legal basis. Firstly, on the parties the parties doesn't have right to file a case before the court. And secondly, I don't think the courts in India has jurisdiction to accept the case, because the parties has explicitly mentioned that the seat of arbitration in case of any dispute arising out of their contract would be in Bhutan. So technically, no. I don't know if that answers your question. So if not, then probably, if I may further explain, because the role of the court will only start once the arbitration has completed the resolution of the dispute. And except in some cases where if there's any interim measures and if they apply to the court for stay of order or interim measures that has been decided by the arbitration tribunal as per the Arbitration Act.
Yes, thank you.
Yes, thank you. Tandin, over to you.
Let's to briefly answer. So there's something called the pre-qualification under the procurement rules and regulations. So in particularly for large and complex procurements or that involve high cost of preparing detailed bids. So there's something called the pre-qualification. So whereby the agency, before actually carrying out the normal tendering process, can actually pre-qualify the contractors or suppliers based on their financial capacity or their technical ability. And then, of course, there are other general suitability criteria prescribed in the PRR. So based on these provisions, I think there's a provision to pre-qualify the contractors and then select the best capable and performing contractors.
Thank you, Tandin. Sir Kile, do you have anything to add to the remark made by Sir Tandin?
No, madam. In the interest of time, I don't have anything.
Last, thank you, thank you, Kile. Thank you, everyone. As a moderator, I think I would like to take this opportunity to ask one question to Professor Sheila, Professor Rachel, and Sheila. You know that we have a national competition policy 2020, and with the pandemic and a lot of complaints that we've received during the pandemic is the hike in the price of commodities. So do you think having a competition law or a policy, do you think it will effectively control the prices of the essential commodities? And also if you can share with us your experience as to how the competition authority that you represent dealt with the price hike caused due to the pandemic. caused during the COVID-19 pandemic. If you could very briefly sort of answer this question. Thank you.
Sure. Perhaps I'll answer briefly for Australia and then pass to Sheila for Malaysia's perspective. I think one thing we need to be conscious of in relation to pricing control is that competition authorities traditionally shy away from seeking to control price. Some jurisdictions will consider excessive pricing, so pricing at a very high rate, to be an abuse of dominance, but not all jurisdictions take that approach. So it will depend on the particular approach to abuse of dominance taken in Bhutan as to the role that the Competition Authority takes in relation to high prices. In Australia, the competition regulator here avoids getting involved in setting prices, largely because it's fraught with problems. You know, how do you determine what is a fair price and who says something is high and who says it's not high? What we have done here in relation to COVID is two things. Most recently, we've experienced some excessive pricing in relation to the rapid antigen tests. And although the ACCC does not have any jurisdiction over the prices of them, they have used their investigation powers to make inquiries about what prices are being charged and by whom. And they're feeding that information into the Australian Federal Police. And the police are implementing a new regulation that is seeking to criminalise rapid antigen test excessive pricing. The other thing that the ACCC have done throughout the pandemic is regulate collaborations between parties. So parties here have sought to work together to ensure security of supply of essential goods and services. So where things were hard to get, suppliers were working together in order that consumers could obtain and still buy the goods and services they needed. The Australian Competition Commission played a really active role in ensuring that those cooperations were as pro-competitive as possible. So they've regulated that collaboration, and now they're assisting the police in relation to breaches of the regulation in relation to pricing of the rapid antigen tests. But Sheila, I know there's a different approach in Malaysia.
Yeah, okay, I'll just quickly. Price Control Act. We have the Price Control Act, and controlling prices of essential items is really a consumer issue, you know, which most countries have different laws to address, you know, price gouging and, you know, misleading advertisement on prices and things like that. But and during the pandemic, because I'm no longer in the commission, but I've been following the commission's way of handling the pandemic, a lot of the issues raised were actually referred to the Ministry of Domestic Trade, which is another ministry which deals with, you know, illegal price increases and you know, anything that's related to prices. And what happens usually is the commission, the ministry is the main driver, and the ministry and the commission actually work together to determine, you know, if there are any cartel practices or, you know, abuse of dominance in that particular, you know, market that they are dealing with. So basically, because price increase were, you know, that were being you know, experienced by not only Malaysia, but I think a lot of the countries. So, you know, they actually had to consider various factors, and it was really unavoidable, you know, for price increases to occur. And, you know, things like, you know, the mask and the antigen rapid test, they were all, of course, came under, you know, price control. So, you know, that was how Malaysia managed the situation. Thank you.
Thank you, Professor Rachel and Sheila. And with that, I would like to thank all the four panelists for your wonderful presentations and sharing your insights with us. As is usually the case with wonderful panels, we're really out of time. We're getting queries from the audience to whether they can ask questions or not, but we're really out of time. I'm very sorry for that, but I hope we can continue this dialogue beyond and carry on the conversation beyond this conference. Thank you all for being here today. I wish everyone a very good day ahead. Kadinchela, thank you.
Thank you very much for having us.